Aquilian action, one of the founding stones of delicts. There are two actions. Mainly, we have Aquilian actions, which deals with wrongs of substance, and then there is actio inuriandi, which deals with wrongs of personality. Now, today we're going to deal specifically with Aquilian action and its elements as well as the available defenses for the defendant. So we'll look into that. Next. So, the modern Aquilian action has 6 elements. We have voluntary conduct, unlawfulness or wrongfulness, capacity, fault, accusation, and loss. And we are going to deal with each and every one of those elements in detail. Voluntary conduct. Voluntary conduct, we divide it into 2. We try to give substance to this element by dividing it into 2, and we first try to give a definition of what it means to have voluntariness as well as what it means to have conduct. Now, in terms of voluntariness, in criminal law, voluntary conduct is conduct which is controlled by the accused conscious will. Thus, logically, the same applies as well in delict. So, this is when a person's will is reflected, right? So that is voluntariness, right? So this is what we are going to deal with. Control by the defendant's will implies the existence of a mental capacity to direct one's muscular and bodily conduct or movements, therefore depends on the person's mental capacity at the time of the alleged wrongful conduct. Now, I've stressed this enough. I've talked about the fact that when it comes to delictual actions, we are looking at what was there at the moment when the delict was done. So here we are looking at whether the defendant at the time of the delict had the mental capacity to control his movement, control his bodily conduct or her bodily conduct. We shan't be discriminatory in this regard. Next. Now, as we continue on with voluntariness, we look at the fact that the person must be with compos mentis, or of sound mind and sober senses. Now, an example of a person who does not have a sound mind or sober person is that of a person who has an epileptic fit or is dead blackout drunk or acts unconsciously. There are a lot of reflexive bodily movements that happen unconsciously. So in that regard, you are unable to control your bodily reflexes, and thus any conduct that is done by your body at that time is not considered voluntary. Now, in Aquilian action, we investigate the conduct that set out the causal train in motion. Now, when a delict or a wrong has been done, we look at whether this wrong, did the person who did this wrong have the mind or mental capacity to control his actions. We shan't impose liability on a person that was unable to control his or her bodily movements. Now, reflexive bodily movements in a state of unconsciousness are not legally relevant conduct, like I said before. Now, a question comes in: voluntarily driving a car while unmedicated with epilepsy. Now, we talked about this in class. The examples that I gave. In this regard, we talked about the case of State versus Rensburg, 1987, volume 3 SA 35. Now, in the criminal case, X had blood tests which had led, apologies for the spelling error, which had led to a fall in his blood sugar levels. His doctor did not warn him that this might happen, and it was not reasonably foreseeable. X was thus not responsible for the accident and found not guilty of negligence. Now, this person, not only was he unable to control his bodily movements, such lack of control was not negligence on his part, because he was unaware and he was not told by the doctor that there was a reasonable possibility of this happening. So he was not liable for that incident. Now, as we continue with voluntariness, the circumstances at the time of the defendant's preceding voluntary conduct must have been such that a reasonable person would have foreseen the possibility of harm to another and would have taken precautions against it. Now, I also gave this in class. There's a difference between when a person reasonably foresees and takes precautions, right, against such, and if those precautions do not work, then he is not liable because he has done his part, but the accident or the delict did happen despite all the effort. Now, this is different from a person that can reasonably foresee that something bad is going to happen from this conduct that I'm about to do, but does not take precautions or reasonable precautions to keep that harm from happening or that wrong from happening. That person would be held liable, and this is seen in the case of Warsaw's and another versus Pickles, 1985. It says that D was found guilty of negligence. While driving, he had suffered a diabetic coma due to low blood sugar. He had suffered a previous attack resulting in an accident, and he knew his condition and how to control it, even if he had not been told by his doctors. This person could see but did not take reasonable precautions to keep that harm from happening. Now, as we continue on under voluntariness, we look at the circumstances at the time of the defendant's preceding voluntary conduct must have been such that a reasonable person would have foreseen the harm to another and would have taken precautions against it. Just repetition. Now, off to conduct. A person can only compensate for what he or she did as opposed to the thoughts despite the severity or evilness of whatever thoughts that we may have. We all have intrusive thoughts that haunt us every day of our lives. We think horrible stuff and imagine horrible things against our enemies or even our family and friends. But those thoughts are not something that would be held against you in court. They're not delict, because delict refers to conduct. They must have somehow been processed into actions. Now, conduct may be a positive act or an omission. Let's look at those. Now, a commission is a physical conduct or in the form of a statement. But with regards to statements now, the law recognizes that words are more volatile than deeds, and that some restrictions should be placed on the scope of liability in such cases. So they're saying that words are more volatile and easily abused than deeds. So there is some restriction with regards to liability in cases of where a person's voluntary conduct entails words, right? And this is noted from the case that is noted there. Now, positive conducts are regarded as prima facie unlawful, while omissions are regarded as lawful. We do not have a duty to be walking Jesus's. Now, a positive conduct that results in a delict is considered on the face of it to be unlawful. That's what prima facie means. Now, while of prima facie, some would have it pronounced, but we are all subject to our own freedoms of expression, and I choose to refer to it as prima facie or prima facie, but I prefer prima facie because I am entitled to my choice of words and expression. Now, as we continue, we do not have a duty to be walking Jesus's. Now, I gave an example in class when we were referring to a child that is on a bench, and that child decides, or obviously did not decide, but just drops on the floor and dies. Now, I had no duty in that regard to save and be Superman for the child, or to be the child's savior. There is no duty on any normal individual to be walking around and saving people in the streets. However, that is different for different offices, especially with regards to omissions. We'll talk about that one. Now, with regards to omissions, it is regarded unlawful if there was a legal duty to act. Now, in the state of Minister Van Policy versus Ewells, 1975, we see the victim was assaulted by the police sergeant in a police station charge office in the presence of several police officers, and the question before the court was whether other police officers were under a legal duty to intervene generally, and say that generally, and the court said in passing that generally there is no legal duty on a person to prevent harm to another, like I noted with the example of the baby, and but the legal convictions of the community demand that a duty be placed on the police to prevent harm or on another person, right? So, in regards to police or any person who has a legal duty to act, he is supposed to act, but fails to act, then they have voluntarily acted or conducted themselves in this regard. So it does apply in this case and will be held liable. Let's continue. It is difficult to distinguish between an omission and a commission. An omission to take certain measures in the course of some activity, therefore not necessarily be a form of conduct, but indicate the action was negligently performed. Now, I also explained this in class with regards to an example about when a car drives through a stop street into another car. On the face of it, you could say the person has voluntarily acted or commissioned, it was a positive act, but failure to stop at a stop sign is also could be considered as a negative positive conduct, negligent positive conduct. There's also an error there. It's supposed to be a omission because you have a legal duty to act in that regard and you omitted to act, right? So now it can be either an omission or a negligent positive conduct. Now it's different now it gets harder for us to differentiate between the two. Now as we continue, we are now off to the next element, which is unlawfulness or wrongfulness. Now, the conduct of the defendant must have been wrongful, which is a conclusion of law that a court draws from the facts before it. Unlawfulness of a conduct is tested against the standard of reasonableness, considering the legal convictions of the community or invoking public policy or legal policy. I have stressed this 100 times in class. We use the standard of reasonableness when we are looking whether a conduct is lawful. In determining unlawfulness, the court has, by means of an ex post facto inquiry, after the delict has been committed, balance the interest of the plaintiff, the defendant, the community, and the administration of justice. Now, the ex post facto inquiry, it is an after the fact inquiry, because the inquiry after the delict has been committed. This inquiry is just the court now balancing all the interests that are in play. We are looking at the plaintiff, the defendant, the need to administer justice, as well as the convictions of the community. The role. Now, when we decide on the type of conduct, whether it is lawful or unlawful, we enter the element of lawfulness or unlawfulness or wrongfulness. We want to establish the type of conduct. Don't forget, we first noted that the conduct has to be voluntary and it has to be an actual conduct. Now, not only that, but it also has to be unlawful conduct. So we are dealing with trying to establish the type of conduct, and in doing so, we are limiting the ambit of liability when it is recognized. So unlawfulness helps us to limit the ambit of liability by also adding another element that has to be proven. Now, in the case of Musadzikwa versus Ministry of Home Affairs and another 2000, the court stated that to determine wrongfulness or reasonableness of any given conduct, the court is enjoined to make a value judgment based on the bonus mores in the sense of legal convictions of the community as to what is fair, just, and equitable. In the case, the police had used automated weapons to cue a riot, injuring an innocent passerby, and the court stated that it does not condone harmonious community relations to use automated firearms on members onto a densely populated urban shopping center. Though entitled to use firearms to disperse the rioters, it was unreasonable to use FN rifles, and so they were liable. So now this is almost an ideal case with regards to looking at conduct. We first established that there was conduct which was voluntary conduct, right? And now we are looking at the lawfulness of that conduct. As we look at the lawfulness of that conduct, they used the balance of interest that we talked about there in the interest of the plaintiff, the defendant, while taking into considerations the legal convictions of the community, the bonus mores, and they established the decision of the court. As we continue, not only with regards to omissions, when we started, we said that an omission happens when there was a legal duty to act, right? But there's also omission in regards to where a person, through her own conduct, created a potentially dangerous situation, and in that case is under a legal obligation which she created herself to prevent the danger from arising. I gave an example in class about the fire in the backyard, and if it burns someone and so forth, whether you had a duty in that regard, and we talked about that example. Now, a drowning child scenario that I instituted. In the case of a drowning child scenario now, if you had put the child in danger, if you were the one who initiated that possible scenario, then you have a legal duty to act. Now, there are also exceptions wherein there is a special relationship or a person is a person of public office. They also have a legal duty. They don't have to have created that potentially dangerous situation. Let's continue on. The case of Silver Fishing Corporation versus Maweza, the owner of a fishing vessel has not only a moral duty but a legal duty to provide adequate alternative means of propulsion or suitable means of rescuing the crew of a drifting boat or both. It is not a special duty or subject to peculiar restricted rules. It is a duty to act reasonably, and such may arise out of the circumstances of the case. Now, as you read up on the case on your own, I can't get into detail with it because of the time. We have an extenuatingly gruesome number of slides that we have to finish, so I can't go into every case, but the situation is quite clear in this case. The court stated that a duty had arisen with regards to the facts of the case, and you note the duty when you read up on the case. Now, as we continue on, unlawfulness involves the infringement of a legally protected right or interest. The court must therefore first decide whether the right or interest is legally protected. If it is legally protected, then the court must decide whether there had been an infringement of this right or interest. And in deciding this, the criteria they use is one of reasonableness, considering the legal convictions of the community as determined by legal policy and so forth. Now, crystallized defenses excluding unlawfulness. There's a whole list of them. There are certain defenses excluding unlawfulness of conduct that are available to the defendant, namely consent, which includes voluntary assumption of risk, private defense, necessity, impossibility, disciplinary chastisement, obedience to orders, statutory authority, and negotiorum gestio. We'll look into detail these defenses later, but we may look at some. Now, as we continue with crystallized defenses, if the defendant raises these defenses that I just mentioned, the judgment may be for the defendant, which means it may be in favor of the defendant. Now, in general, the defendant bears the burden of proof on a preponderance of probabilities. As we continue, capacity as an element of Aquilian action. Now, adult and sane sober persons are presumed to have the capacity to appreciate the wrongfulness of their conduct or to act in accordance with that appreciation. Now, a child under the age of 7 and a person suffering from mental illness, according to Tanner versus U, A, and C, may lack such capacity and so escape liability. The inquiry is a preliminary one. So the moment they get into court, this is the first thing that they look at. Do the defendants have the capacity to act? And if the defendant is an adult, sane, and sober person, there is a presumption that is there that they do have the capacity, and it is up to the defendant now to come in and say, no, I'll prove that this presumption is wrong. Now, in regards to capacity, it is assessed subjectively in the cases, in the circumstances facing the defendant. So they look the circumstances facing the defendant and they assess whether the person has capacity or not. Now, in criminal cases, provocation or emotional stress exclude a person's capacity, but thus far, there is little case law with regards to that extension to civil court. This is according to Batchel and Mitchell. Now, as we continue on, there is a presumption that a child between the age of 7 and 14 lacks capacity, but that presumption weakens as the child approaches 14. Now, what they're saying here is that the older that child is, the older that the more that presumption is lowered. We would assume that a 14-year-old has mentally developed as opposed to a 7-year-old. As we continue on, we have Weber case versus Santa versus something that I shan't dare pronounce. The appellate division was faced with determining whether a child aged 7 and 2 months had been negligent in regard to his own injuries, and the court judged that subjectively, including an inquiry into the maturity, knowledge, and experience. Now, in class, I was talking about the different factors that the court noted that they considered. The court noted in Weber that when establishing the capacity of a child, just because that child is intelligent in school does not mean that person has a certain mental capacity that is grown than we would expect it to, knowledge and so forth, they would consider it as a factor, but it is not, it does not overcrowd the rest of the factors that are considered. Now, as we continue on, however, the parent of a child under the age of 7 or the person responsible for the supervision of a mentally incompetent person could be guilty of negligence. The person fails to take diligent steps to ensure that the person lacking capacity does not commit a delict. This is straightforward. I explained this in class. If a parent of a child negligently leaves the child to do whatever they wish, and they in that action they harm another person, the parent would be held liable for their negligence. Same case in a mentally incompetent person. Now, the Q Facipe Aliam per se doctrine says that if a person uses a person who lacks capacity to commit a delict, the person who does this can be guilty himself of the delict even though the instrument was a person lacking capacity. So if you as a fellow law student think you can evade the law, or at least try to defraud the law by using a mentally incompetent person to commit a crime, then this doctrine already has outworn you. This doctrine says you shan't escape liability in that case. Now, as we continue on, we're now off to the element of fault. Fault under liability is either intention or negligence, dolus or culpa. Now, let's look into details with all those. Intention, we're looking at a legally reprehensible state of mind or mental disposition encompassing the direction of the will to the attainment of a particular consequence and consciousness of fact that such a result is being achieved in an unlawful and wrongful manner. Now, a person has intention if their state of mind comes into formation through act which is unlawful and wrongful. Now, here they're saying that the concept is subjective, as always, and they say that intent is present only if the defendant in fact intended to bring about a particular result and was at the same time subjectively aware of the wrongful character of his or her conduct. This straightforward stuff. And then we have at first related to defamation only. This intention element, it first related to defamation traditionally, but now it applies all throughout the law of delict, even applies to cases like assault, rape, and malicious injury to property. Now, as we continue, we ought to know the forms of intention. We looked at dolus directus, dolus indirectus, dolus eventualis. We say that dolus directus is when your will is attained. So it says that the actor directs his will to attain a particular consequence. For example, one would act with the objective of causing death to another and he murders that person. That is dolus directus. And we have a case in that regard. The defendant was guilty of fraud when he sold shares sent to him in error, and he knew he had no right to the shares and had sold the shares knowing that he had no right to do so. He was held liable on the basis of unjust enrichment. We talked about this case in class. As we continue on, we had also dolus indirectus, if a person or an actor intends on attaining a certain objective but at the same time foresees that another consequence must necessarily flow from the conduct. This state of mind is dolus indirectus. It must be inevitable and inevitable consequences. Let's say you shoot someone through a glass. We gave that example of the ma'am sitting outside of class. You want to shoot them, and you know naturally if you want to shoot them through a window, the window will break. There is in no way, unless you are in supernatural world, there's no way you would shoot a person through a window and the window does not break. So you have dolus indirectus because it is a natural flow or necessary flow from the conduct. Now, as we continue on, dolus eventualis, we looked at that one as well. If the actor within the intent to attain an objective at the same time subjectively realizes or appreciates that another consequences may possibly result from one's conduct and reconciles oneself to this possibility, it is not enough to reasonably foresee, but it must be subjectively reasonably foreseen. Now, reconciliation refers to acting with reckless disregard of the foreseen possible consequence. Now, we gave an example in class that if you did try to shoot that person through a glass and you know you are in a crowded place and you know there's a reasonable possibility that another person would just come by while you're trying to shoot the lady, then there is dolus eventualis. Now, let's continue on. The defenses that are there under fault. We have the defense of mistake. You can claim that it was a genuine bona fide mistake, whether it be a mistake in law or a mistake in fact. It is a defense that can exclude intent. This is noted in Marcel's versus Van Neren. Now, there's also another defense. You can say that it was all a joke. You were just joking with the plaintiff, and the test is not an objective one. Subjectively speaking, you're just joking with the defendant, so jest can also be a defense. Provocation as well. In extreme cases, one may be provoked to a degree or anger which effectively impairs or destroys one's mental capacity to have dolus or culpa, and must show that the conduct took place without premeditation and great sudden anger. So that is straightforward stuff. As we continue on, we have defense of intent. We look at intoxication and emotional stress. Is almost the same with provocation, but in this case you are drunk in so much emotional distress as that you become so blind to your own actions. Now, in exceptional cases, a person may be intoxicated to such an extent that he or she lacks capacity to be at fault. To formulate intention, the test is subjective and determined on a case-to-case basis. Now, there is also capacity. An insane person cannot be held accountable for his or her conduct. We have Minister of Justice versus Hoffman. Youth can also be raised as a defense, as in the noted case. Now, we noted that fault can either be intention or negligence. Negligence now is one of the founding, I'd say it is a very important principle that is founding on the law of delict. It says here that conduct is negligent if the actor does not observe the degree of care which the law of delict requires. Negligence is concerned with the protection of society against the dangers imposed by conduct that falls below the standard of the average prudent person. Now, I've stressed this enough in class. The moment that you are born, you have a duty that is conferred to you by society, an expectation that they have that towards you. Society says that in your day-to-day activities, you are trying to achieve your goals and dreams, you shan't harm any person, be it intentionally or negligently. Now, this duty of care is quite clearly noted in this element of negligence. Now, the nature of this element is that conduct is negligent if the actor does not observe that degree of care that the law of delict requires. Negligent is concerned with the protection of society against the dangers posed with it. The objective test demands that one's conduct must adapt to the ideals and standards of a particular community, like I noted. And the standard of care which the law demands is ordinarily that which a reasonable person in the position of the defendant would exercise in the same situation. Now, there are an infinite possible scenarios. Make setting concrete principles impossible. So here it says that because there are an infinite possible scenarios where a person would be negligent, it is impossible for us to set clearly defined principles of negligence. But they have tried. So the test or the requirements that you need to prove negligence are as follows. They test it out, or they test the conduct by using the following tests. So they establish whether a reasonable person in the same circumstance as the defendant would have foreseen the possibility of harm to the plaintiff. And if so, would a reasonable person have taken steps to guard against that possibility? And did the defendant fail to take the steps which he or she should have reasonably taken to guard against it? As we continue, now as we noted from the first description of negligence, there was a need for a duty of care. Now that duty is explained. A person is said to have breached a duty of care when he fails to foresee and guard against harm which a reasonable person would have foreseen and guard against. It is noted in this case where a mentally unstable policeman was given a weapon and was assigned to guard a house. He wandered off and shot some civilians. The minister was held to have been negligent in arming him, knowing his mental state. It was reasonably foreseeable that he might end up harming others, and the ministry owed a duty to the community. Now they were held liable. Now the standards of reasonableness that we talked about, it is a criteria that is very important in regards to negligence. Now what it means for the reasonable person test, or the standard of reasonableness that is expected of us, they're saying that the criteria places the reasonable person in the same external circumstances as those facing the defendant at the time of the alleged delict, and the test is objective. The reasonable person is not placed in the same intellectual, educational, mental, or emotional circumstances as the defendant, as this would severely undermine objectivity. The reasonable person is therefore the legal personification of the ideal standard of care which the community desires its members to exercise. I've stressed this enough. The third point there is saying that the reasonable person is looked at as an average individual, not someone with superpowers and his ability to save the world, but he does not even have to live up to the whatever kind of raised status that the defendant would have, or the knowledge or whatever the defendant would have at the time of the delict. So this is an average person that is personified. And in State versus Marais, the accused contended that the alleged delict was a result of being stung by a bee, and the court was of the opinion that a reasonable person, even in such an emergency, would have acted to precipitate, as the accused would had removed both hands from the steering wheel and collided with a parked car. Now, we talked about this case in class. A person encountered a bee and they removed both of their hands from the wheel, and the court said that such actions are not those of a reasonable person. A reasonable person would have had stopped, made an emergency stop, and he did not do so, and thus he was negligent. Continue now. Where the standard of reasonableness is raised and where the standard of reasonableness is lowered. Now, when we first talked about the standard of reasonableness, I said this is an average person, but there are special circumstances. Just like any general rule has exceptions, there are exceptional cases where in the standard of reasonableness, the average guy that is personified is raised to a certain status, he's given a work qualification and certain skills, just like the defendant. Here he says that in the cases of doctors, the degree of skill required of them is that of a reasonably expected person engaged in such a skilled activity. They do not give the reasonable person the highest possible professional skill, but the reasonable practitioner in the relevant field. I talked about this in class. I said they do not give the reasonable person that they would be using as a test against the defendant. They do not give him the highest possible skills available, but they just give him the relevant skills of an average doctor, of an average lawyer, or whatever the case, whatever profession that the defendant has. Now, in some instances, the standard is lowered. In cases of a beginner, it seems equitable to expect a beginner to have skills of an expert, but his lack of skill and experience should not excuse his behavior if he exposes the public to the risk of harm. Straightforward stuff. We explained this in class. Let's continue as we try to finish the slides. We are almost halfway. Now, as we continue with this lesson, it says that a reasonable person who is blind is not expected to see. Therefore, his disability is taken into account when assessing the standard to which he must conform. But if he acts in a situation that demands good sight, he may be held negligent. Now, this straightforward stuff, in cases of a lawyer, it's the same situation with that of a doctor, right? The standard is raised, they're expected to exercise reasonable skill and competence. If they fail to measure up, then they are sued for damages. Now, in cases of delict, lawyers and other professionals, you see that from the delict guide soft copy that I'll give you, they lay out different cases with regards to lawyers and other profession that have been had in court. Cases like Masama versus Bow Drillers, a negligent lawyer was ordered to bear the cost himself, and the matter was reported to the Law Society. As we try to finish up, the foreseeability test is one of the tests that are there in the test for negligence. We say that this is the cornerstone for the test for negligence. The first step in assessing the standard of care requires it to determine whether the reasonable person would have foreseen the reasonable possibility of his conduct injuring another person or property. We see this. We hear this in the case of Kruger versus Courts in 1966. A mere possibility is not enough, but it must be a reasonable one. We talked about this in class. The possibility of harm therefore refers to the chance of harm actually materializing and to the gravity of the situation if it does. Now, you should be able to see the possibility of the harm, the gravity of the situation, and the defendant is not required to foresee the particular consequences or the extent of the harm or the precise manner of its occurrence, just the fact that it is reasonable that it might occur. It does not have to be precise. For example, I gave the example that you may foresee that someone is shot, but you may not foresee that you'll be shot in the head or in the foot or slash his ear out. You should just reasonably foresee that the person would be shot. The determination requires three elements that I talked about in the case of Harvest Corporation versus Duncan. A distress flare, we talked about this one. A distress flare was shot, and then as a result, it blew up a cold store that was nearby, and the court stated that it found that the fire was not reasonably foreseen because the people that had shot the gun would not have reasonably foreseen that there were other things that were on the cold front, on the cold store, that would double the fire and cause an explosion. Now, if the chance is slight and the consequence is trivial, the reasonable person will not take precautionary measures. We talked about this and how it relates with regards to Bolton. versus Stone. So if there's a 100 million chance that there will be an occurrence and the consequences will be trivial, then a reasonable person would not take reasonable steps to try and stop that harm. They'll say, there's a 1 million chance, then taking reasonable steps would be really a waste of my time. Now, this in Bolton versus Stone was when a golf ball hit a woman on the road, which was 1 in a trillion chances, but it did happen, and the court you look at as decision. Therefore, negligence is failure to minimize risk. As we continue on, now, reasonable steps to guard. We're still looking at the test for negligence. Don't forget, now this is one of the second elements. It says that the person who reasonably foresees harm should take reasonable steps to guard, and what they consider to be reasonable. These are the tests that they use. The factors considered: the probability of the harm materializing. We look at Bolton versus Stone, the seriousness of the harm, and whether there was cost or difficulty of avoiding the harm. Now, in this case for Hetero versus Morope, the relationship between the first two is that if the harm is serious and if it happens, the reasonable person should guard against that harm. But if the harm is very slight and not very serious, it does not guard against the harm. The harm is trivial, and if it happens, a reasonable person will not guard. We talked about this earlier. This is said in Hetero versus Morope. Now let's continue on the cost and difficulty. Now, when you want to establish whether you should take reasonable steps or not, you look at whether it will be costly or difficult to put those guards or reasonable steps to avoid the harm. Now, we talked about these cases in class. Because of the length of this video, it will be exaggeratedly long. I will not go into detail. These straightforward cases you should read on your own. As we continue, contributory fault is very important. A person suffers damage which is partly of his own fault and partly of the fault of another person, and a claim in respect of that damage shall not be defeated by reason of the fault of the claimant, but the damage is recoverable in respect thereof should be reduced by the court to such an extent that the court may deem just and equitable having regard to the respective degree of fault. Now, we talked about this. We have the Damages Apportionment and Assessment Act with regards to contributory fault. Let's say, for example, a person passes a stoplight. They pass a stoplight, and then another person who also passes that stoplight comes and runs into them. They are the victim, but they are also at fault. Their negligence caused them to be in harm's way. Now they contribute to the fault, and the court will not remove liability on the part of the defendant in that regard, but they would give appropriate compensation having regard to what they deem just and equitable with reference to the Damages Apportionment and Assessment Act. A clear rule in common law that a plea of contributory negligence cannot be set against a claim on intentional wrongdoing. Here they're saying that when a person intentionally causes a wrong, they cannot claim that even though I intentionally caused the wrong, this other person contributed as well negligently to the claim. Contributory negligence cannot be raised in that regard. So if there is intention, that is, if there is dolus directis, indirectis, eventualis, you cannot raise negligence, another negligence from another person. Now, a plaintiff who has intentionally contributed to his or her on loss cannot claim damages for that loss or part of it from a negligent defendant. Same applies to the plaintiff as well. If there is intention on either parties which has caused the harm in question, then contributory negligence cannot be raised as a defense or to try and lower claims or something like that. Now, causation as an element, we say the person must have caused the harm. There must be a causal link between the harm that has been encountered as well as and the actions of the defendant. Now it says that even though the conduct of the defendant is proved to be unlawful and negligent, it must also be proved that his or her conduct was a cause of the harm suffered by the plaintiff. Plaintiff must prove causation, and there are two types of causations. We have factual and legal. Now going into detail with factual causation, the test for factual causation is sine qua non, or the but-for case. This straightforward test, it says that if the harm would not have occurred but for the defendant's conduct, then the defendant's conduct is a factual cause of the harm. If the harm did occur even though the defendant's conduct, then the defendant's conduct is not the cause of the harm. So it's a addition removal thing. Right? You say that if the defendant's conduct involves an omission, then it involves the hypothetical addition. We talked about this in class, this straightforward stuff. We are looking at whether the defendant's action did cause the harm. So if we can hypothetically remove that action and the harm still occurs, then the defendant is not liable. Let's continue. Now, this is the case of Mr. Police versus Kosana. We talked about this case. It's very, very long, but you should know this case, and it should be in your skin and in your blood, and you should dream about it late at night. Now, as we continue on, two problems need consideration. If the negligent act did give rise to the claim, and whether the negligent act is linked to the harm sufficiently close or directly for legal liability to ensure whether it was too remote. It is a juridical problem requiring consideration. Now, we are now critically looking at the factual causation and looking at the sufficiency of the causation. You see the arguments that are laid down there in the books that I have recommended and the case law as well. We're looking at whether the conduct was sufficient enough to have caused the harm. Now we have legal causation. The question for legal causation of the delict, it is that legal causation helps in limiting liability by determining whether or not a factual link between conduct and consequence should be recognized in law. Right? And then the question of legal causation is essentially one of limiting the boundaries of legal liability. Now let's continue. There are a number of tests that are there: legal causation, direct consequence, adequate consequence, foreseeability test, novus actus interveniens. We'll talk about it in the composite test, which compiles all these tests. Now let's continue. Here, direct consequences, they look at whether the defendant is liable for the direct factual consequences of her wrongful conduct, consequences which flow in sequence from the effect of the defendant's act upon existing condition, forces already in operation at the time without the intervention of any external forces. This straightforward stuff, despite the very long statement, they're just clearly saying that did the defendant's action result directly to the consequences in question, the consequences being the delictual wrong that is in question. Now the case, I talked about this case, it is an example of when the direct consequences of the plaintiff cause the harm, and the court established that it did not. Now, novus actus intervenes, which is directly translated to new act that intervenes. Now, an intervening cause is an independent, unconnected, extraneous factor or even event which is not foreseeable and which contributes to the occurrence of harm after the defendant's original conduct. So we're looking at a new intervening act that comes as a third act, unforeseen, and breaks the causal chain between the defendant's action and the harm that is in question at the time. Now, a novus actus intervening is the effect of completely neutralizing the causative potency of the defendant's original conduct. Though the link is there, it is too tenuous or it is too weak. If a reasonable person would have foreseen, then such event is not considered a new event. Now, there's a case there, you read upon it on this principle. Now, adequate cause, in short, is almost the same as direct cause, but they're just saying that was the cause adequate, was the action of the defendant adequate enough to have caused the damage? But it is similar. Now, as we look at foreseeability, a wrongdoer is held liable for only those factual consequences of his or her conduct which are reasonably foreseen. This one limits liability. If you do not reasonably foresee, then you are not liable. The court held that only the foresight of a reasonable person can determine responsibility in this case. Now, there's the thin skull syndrome. The thin skull rule, the court held that it is reasonably foreseeable that some people in society suffer from ailments or other conditions which make them more susceptible to injury or other persons. We talked about this in class. We said there are some people who are just walking accidents waiting to happen, and we in society should reasonably foresee the existence of such people when we are conducting our day-to-day activities. And if you do harm such a person, you will be held reasonably liable. Now, the general rule is that the defendant must take their victims as they find them, and if they are harmed, the defendant should be liable even though a person with that same condition would not have, let's say, died. Now, R versus John, the court held that if you assault a person moderately, it is reasonably foreseeable that a person with thin skull may die. So they do acknowledge this thin skull rule. Now, as we continue the composite test, we look at the Morchetti case or Bentley case. The court held that legal liability will not arise if the unlawful act was in the chain of causation so remote that the event which directly brought about the loss, that it would be against the policy of law to visit the legal liability for the actor. So the Bentley case, this is what the composite test is all about. They look at all those criteria that are listed down. The criteria puts emphasis on legal policy, reasonableness, fairness, and justice. Now, in cases of multiple causes, we said in class that there are some rare cases wherein there are multiple people or causes that would have caused the harm, be it natural elements or so forth. The court said in Rudman that in such instances, the Supreme Court would just do its best, sorry for the spelling, it would do its best it can in such circumstances. It found the defendant liable to pay half of the damages proved to have been suffered. As we continue, say that the plaintiff, whose wife had been killed by negligence of the defendant's servant, alleged he had suffered damage through being deprived of the comfort of his wife and assisting the child. So in this case, we're talking about Aquilian action. We're talking about patrimonial loss. It seems that I skipped another slide, but we are now talking about patrimonial loss. These are loss of substance. Now, the two cases that I just stated prior, the court were just establishing that if it is not something that can be substantiated in monetary form, then it is not an Aquilian action. So you read up on those cases. Now, classification and assessment of damages, we looked at the once and for all rule. When a delictual act has caused you harm, you go to court and file as many actions as possible, as possibly drawn from the act. And if you leave any one or two, you cannot then go back to court and try to institute another action with that same act. So there's a rule that says that you should just submit your actions in court all at once. The mitigation rule requires that the plaintiff should take reasonable steps to mitigate his or her own loss. We talked about this one. And it says that you should reduce the risk of furthering any more damage what the defendant has already given you. Now, compensation is not the only action that is available to you when there is patrimonial loss. There are also interdicts that you can use, and that can be applied by a person who anticipates the causing of such loss or wishes to prevent any infliction that is reprehensible. And for you to get those interdicts, be it a final interdict or an interim interdict, you have to prove the three elements that are stated there. In terms of a final interdict, you have to prove that there was a clear right on the part of the plaintiff, of the applicant, and there was an injury committed or reasonably apprehended or foreseen. And then we have absence of similar protection by any other remedy, and then those are the elements under interim interdict. Now, as we continue, if you are entitled to damage for impairment or destruction to property, you should also go to court and claim for any consequential loss that you have suffered. Let's say you have damaged your property, and as a consequence of that damage, you lose money or something like that. You should also claim that consequential loss. It is further loss that you have suffered as a consequence of the initial damage. It says here that you are entitled to the loss of the use of a thing, the time taken for repair. And I gave an example of hiring a taxi every day since the collision. You can claim damages for that. It says here that damages are awarded according to what is legally due, because as we noted in the first instance, delict is not about penalty. It is merely about compensation and trying to reinstate you to your pre-delict position. The courts do not consider whether the plaintiff is likely to utilize the award, but an exception was made in Collins versus Administrator, wherein the court decided that the awarding of a baby in a permanent vegetative state was almost for birth would serve no purpose and declined the award. because the baby itself was not aware of her own existence. We talked about this in class. If you are awarded compensatory damages for a damage to a car, even if you don't use that compensation and use it to pay for your for your kids' schooling, then it is up to you. The court usually does not consider all those factors afterwards, merely that you are compensated. But this exceptional case in Collins, they did such. Now, there's a need for you to differentiate between general damages and special damages. Straightforward stuff. General damages are claims in respect of harm which is presumed to flow from unlawful conduct naturally and as a probable consequence. That is the most important factor with regards to general damages. They must flow naturally as a probable consequence. It is foreseen, right? And then the court will decide on the appropriate award based on any comparable cases. This is how they would see the precise value. Now, the precise value is not there, but they will try to look at comparable past cases and see whether they would you do the same in the case before them. Now, with regards to special damages, these ones have to be proved and pleaded, especially in court. And the examples are noted there. These can be precisely calculated and you can prove them in court. Okay, this is what is going to happen. This is the loss that is going to be suffered. Loss of earning capacity is 6 months I will be out of a job. These are the receipts of my pay slips for that I usually have for 6 months, and I'm claiming this because this defendant broke my leg, and as a result I'm unable to continue working. This is special damage. Let's continue. So this is just a repetition. Actual loss is what you claim for in delict. The expenses incurred up to the date of the trial. These are the things that you'll be compensated for in class in trial. Now, damages are the amount to be paid as compensation for the harm suffered. The extent of the harm is calculated according to the sub-formula approach. The formula that I stated in passing, I said the pre-delict value and the hypothetical post-delict value are compared, and the difference in value indicates both the harm and the basis upon which the amount in damages is assessed. Now, I said that for us to assess for us to properly learn about how the court may assess damages, we have to classify those damages, and in those classifications we assess how this damage is assessed in court. And I said that with regards to damages to property, they look at the sub-formula approach that I talked about, and they establish the harm that has been caused. Now, sometimes they look at also the cost of repairs. It may serve as a measure of damages, but they are appropriate measures only when they are fair, reasonable, and necessary. And the courts have confirmed this in the two court cases that I have mentioned. The first one, he just gave one quote, and the court said that this could not prove that it is reasonable, that the cost of repairs are reasonable. And then in the second case, they came in with two quotations, and they took the cheapest of the quotation and used it to evaluate the damages that are to be claimed. And then this is the court case wherein they confirmed that cost of repairs are only considered when they are fair, reasonable, and necessary. The court will award damages for incidental cost as well. Now, damages to bodily harm, straightforward stuff. A person can sue for damages for bodily harm. The case is stated there. We have damages for loss of earning capacity. I talked about this. Defendant harms the leg of the victim, and then the victim, as a result, cannot work for a month. So the defendant is bound or liable to pay the loss of his earning capacity. That month's pay has to be paid by the defendant, and the courts that have confirmed this are there. You look it up. But in this case, we asked the question in class, what happens, let's say a person has an illegal job or does illegal stuff and they get money for it. Can they claim for loss of earning capacity as a result? And this is dealt with in Claminis versus Protea. In South African cases, they said that because the transactions are void and unenforceable, they cannot be claimed for loss of earning capacity. But the situation changed in Zimbabwe in Mite versus Minister of Safety and Security. The court stated that only a figure considered by the defendant, or a figure that has been considered by the defendant for such a loss would be awarded, because the court said that we should also consider public policy. Now, damage for duty to loss of support, we talked about this one. If there's a breadwinner, someone who's supporting you, and the person is negligently killed, you can claim for loss of support. It can be a parent who can claim for a child, as long as you can prove that the person was a breadwinner or was supporting you, then you can claim for them. Now, the court cases that are herein is that they talk about the things that are considered by the court. Let's say, for example, you are a working woman. The court will consider that, yes, you may claim, but they would also consider your salary as well. Say that, no, if you are also working, then they will consider that, and the amount to be claimed would be lower than that of a person who is not working. So these are the two cases that are there. Interest on damages, there is the Prescribed Rates on Interest Act. We talk about the interest payable at the prescribed rate from the date of the cause of action, but the court have a discretion to order that the interest payable is over a more limited period. We talked about this one and the two cases that are there. And then damages for non-patrimonial loss, I stated this in class and said it was necessary to just pass through and establish how damages for non-patrimonial loss are assessed, but we'll look in them in detail when I now under actual inuriandum. Now, damages are awarded in respect of direct consequences of the infliction of the injuries. How do they assess? They assess using comparable past cases, and assessment involves consideration of the duration, intensity of the pain, the nature of the pain, medical evidence, and the general circumstances of the case. If you have thin skull syndrome, it means you feel more pain than the others. The court will consider such a test, so that the test is subjective. Look at the case of Sandler versus Wholesale Co-Suppliers. They talk about these things. Now, damages for loss of amenities of life or disfigurements. And I explained amenities by giving an example about a hotel. When you're trying to book a hotel, they list their amenities, they list their little extras that they provide for their guests to make their stay enjoyable. When you are looking for a house, you ask about the amenities. When you're looking to rent a house, you ask about the amenities. The amenities being the Wi-Fi, is there a pool. It is the little extras of life that make life enjoyable. Now, you may claim for damages for loss of amenities of life or damages for disfigurement. You are now unable to enjoy life fully as a result of the loss of amenities, as a result of the disfigurement that has happened, as a result of whatever that would have happened to you as a result of the defendant. So you are saying, I'm claiming damages because I now have, for example, sexual impotence, or I'm now sterile. I now have a loss of desire for social commitments as a result of the action, so I'm claiming damages for that. Now the next lesson will be action in your reality. We'll talk in detail the wrongs to personality. This was a very, very long lesson. I hope you understood. For any questions, consultations are available. Feel free. And for the next lesson and the others to come, they will be fairly short. So do not be scared away. Thank you.